So, hello to this session on the British Constitution. You'll see as we go through. I'm Dr. Tom Appleby. I'm an associate professor around essentially property law at UWE. You'll see as we go through this, there's a series of asterisks. When we look at the British Constitution, actually it is the United Kingdom of Great Britain and Northern Ireland, so Britain doesn't technically include Ireland, and probably doesn't include the Isle of Man or the Channel Islands, both of which kind of invaded the UK, and so one runs on Norse law and the other one is part of the Duchy of Normandy, so runs on old French law, and has a very peculiar relationship with the British Overseas Territories. Each one of which is either, depending on which way you look at it, an integral part of the UK or its own sovereign state. So that's just a start and a hint of where we're going to go with this. But if we take this back a step, back up, and let's start with you as individuals. So what you do is you lot, and when I say you, you'll see this list of characters who are current crop of students. Actually, not all of you get to vote because you may have the wrong type of citizenship, which doesn't allow you to vote in the UK. You may be foreign, that doesn't allow you to be in the UK. You may be British but living abroad, which also doesn't allow you to vote in the UK. So I'm using the term you rather loosely, which is why it too has little asterisks next to it. You vote for them. The leaders of the British political parties: Arlene Foster, Nicola Sturgeon, Theresa May, Jeremy Corbyn, and Vince Cable. You vote for these guys. Well, actually, I say that you don't actually vote for them. You vote for your constituency MP, who is a member normally of one of those parties, though occasionally you will find that you might have an independent MP who isn't a member of a political party. So you vote for your MP, and then the leader of that particular party, by convention, is chosen by the Queen to run the country. I'll come on to that again in a minute. Okay. Anyway, if they win, your constituents MP, that is, not these particular leaders, none of whom I've voted for, they go there to the House of Parliament. That is, unless they're Nicola Sturgeon, because she's the leader of the Scottish Nationalist Party, but she goes to the Scottish Parliament as she is not a member of the UK Parliament. So they go here. I put an asterisk there too, because quite a few people are there already. They don't need to be voted, they'll be the Lords. So they join people there to in the House of Parliament to go and make laws up for you. And the winning party, and it's quite interesting there, you've got the UKIP one there and the DUP both sharing a line with, I think, the Football Association. I think they have a, just check, but the football have a line. Yep, UKIP. Yeah. It's the Premier League. It's the Premier League. Yeah, so, you've got to be a bit careful with your logos. Anyway, the winning party is generally, unless there's one, well, you might have a coalition, as you have now, is invited by the Queen to form a government. And that could be quite interesting, because it's actually the Queen's gift, not the party's gift. You could have a situation, for instance, where you had a majority party, but you had two smaller parties that formed a coalition and they outnumbered the main party. Or the Queen, the leader, might be so downright disreputable that the Queen doesn't think they're right and so calls another general election. It is an interesting constitutional position that we might find ourselves in as we go forward, as the British Constitution is placed under increasing strain. Anyway, if they're invited to do so, they form the UK government. And interestingly enough, last time I did this, there was a picture of a whole load of people sitting around a table. This time you just seem to get on the government website a list of faces. That's probably because it's easier to replace them. And what the UK government does is they can propose legislation they intend to make which is introduced. They are the executive. They propose legislation which is then introduced to the Houses of Parliament. However, they're not the only route. Occasionally you get parliamentarians themselves by a ballot, I think it is. They can actually introduce new laws on their own. The other thing the government does is it implements policy. It runs the civil service. From these people here become the ministers, and they'll be minister of everything from fisheries to the Secretary of State, the more senior ministers, to the environment, the Home Secretary, the Treasurer, the Chancellor of the Exchequer, the Lord Chancellor, the Minister of Justice. They will run departments. So they'll run departments, and they will also introduce legislation where legislation hasn't been introduced by this other sort of more rare process, actually, of members of Parliament introducing themselves. So the draft legislation, the draft laws, are debated in the House of Commons and the House of Lords, and they also go before select committees. The other thing, actually I've not put it on here, but the other thing that the House of Commons does is it just will actually have a select committee, standing select committee, that will interrogate ministries to call officials to account and call evidence and produce reports, and some of those are very good indeed. Anyway, the main thing in terms of lawmaking is the Parliament debates backwards and forwards, and they insert amendments, and then finally a statute receives what's called royal assent. The Queen has to sign it off. Theoretically she can refuse, and weirdly enough, by prerogative, Prince Charles has the option to refuse legislation that has anything to do with the Duchy of Cornwall. He never does, but it's quite interesting, and it's in there anyway. Then that's not the final hurdle. Often what's happened in the legislation is there's a little clause in there which switches it on. So you might find that not all the legislation is turned on automatically. The minister might actually hold some of it back until it's more appropriate for them to do so. Some of it has never been enacted. That's why when you're looking up legislation, it's no good just looking on the website. You have to check a little further to check whether the legislation is actually in force. And if you're foreign, you'll be wondering what on earth the Queen has to do with all of this. But theoretically everybody is acting in her name, and she is wearing the crown, and that crown is theoretically a representative of the public. So it's one of those things where you go back to the top and the bottom. It's a very complicated system, but it kind of works. All legislation can be amended and repealed. The Parliament, one of the key principles is that Parliament cannot bind itself. But the other thing that they can do is Parliament can what's called delegate authority. It can give powers to ministers or to public bodies, like local government, to make bylaws or statutory instruments of their own motion, and those are generally on very narrow circumstances. They don't want to give ministers wide powers because they want to prevent despotism. So you might find something like the Severn Bridge crossing. There'll be a power there for the minister to alter the charge on the Severn Bridge crossing. What he can't do is declare the Severn Bridge its own country or something like that. So very narrow powers on the whole, but we might come to that at the end of this. Once you have your law and you've got your body of law, legislation meaning the body of statutes, the Acts of Parliament and the statutory instruments, are interpreted by the courts, by the judiciary. That's one of the key things a judge does, is they interpret the law. And sometimes the law can be a little bit woolly, and so there are rules of interpretation, and the court might go in one direction and make a tight or a broad interpretation of it, and then that will be followed. And sometimes laws are made by the courts of their own motion too. If you look at things like contract law or negligence, probably the biggest single cause going to solicitors, negligence, road traffic accidents, that sort of thing. The law governing around there is by and large not made by Parliament, but has come about because through civil law, people like you and me have gone to court, and the courts have had to make a decision there and then, and the law has grown up around that. So we have, on the one hand, in the UK, we have this big body of legislation, statute, written through Parliament, and then we have this other body of law that's made through the courts. That is quite rare. In the other countries have what's called codified the law more, so much of the time you find these things are set out in things like civil codes if you're working on the continent. In the UK, a lot is still what's called judge-made law. Decisions in a higher court hold precedence over those in a lower court. And we have two systems. We have a criminal and a civil system. The criminal system is basically set up. That's the Queen versus the criminal, and they have different rules of evidence. So there the balance of justice is beyond reasonable doubt. The last thing you want to do is take someone's civil liberty away, their freedom, and put them in prison if you have any doubt that they might have done it. Or in the old days, you would have hung someone. So you had to, the balance, you had to be absolutely certain they'd done it. So there's different rules about getting evidence. There's a different standard of proof, and that starts off in the magistrate courts for simple offences, the Crown Court, and then there's a Court of Appeal for appellate processes coming out of those, and similarly, and for civil processes where you're basically, civil law is you're dividing between two parties. So there you're looking at balance of probability, who is more credible, and there small cases are introduced in the county court, larger cases in the High Court, and there's the Court of Appeal, and both of them are subject to the UK Supreme Court, and then potentially for further appeal to the European Court of Justice, or what I haven't put on the slide is the European Court of Human Rights. The European Court of Justice looks on matters of European law, which we'll come to, and the European Court of Human Rights deals with the Council of Europe and human rights legislation, which is completely different to the European Union. Human rights legislation, the European Court of Human Rights, is essentially based on British law and came about after the post-war settlement. So yes, cases, decisions referred to by previous decisions, precedents, as I've got on the list. Very easy. But what happens with Brexit? We've already touched on the courts. Where does the European Union fit into it? Because we've been told that all sorts of constitutional changes are afoot, and we want to take back control. So let's have a look at, first of all, what the European Union does and its impact on the British Constitution, and then how that's going to be repatriated. So, just a potted history of the European Union began in the Treaty of Rome back in the 50s. In fact, began with the European Coal and Steel Community right after the war. The UK was offered a leading role in that, but chose instead to focus on its former colonies, and then was refused entrance to the EU when it applied during the 60s by the French, and then finally joined in 1972. And then it joined the European Community, which was more of a free trade area, although there was still areas of control that we ceded in doing so. In 1992 there was the Maastricht Treaty. What that did is it really set up the Eurozone. The idea of having a single currency was put into the Maastricht Treaty. And then 2009 we had the Treaty of Lisbon, and that established some of the key roles. The President of the European President Council. It created a kind of tightened up the constitution and made Europe a little bit more like a kind of empire or country, if you will. But the reality was that every time a new state joined, Europe kind of accreted powers to itself. Whether you like that or not is an interesting question. So then in 2016, from the British point of view, we had the European referendum and voted to leave the European Union. Now the trouble is, leaving the European Union, it is a bit like the Hotel California. You can enter, but you can't easily leave. And even that process proved difficult. Mrs May proudly announced at the Conservative Party conference she would issue Article 50 in March, but it turned out she didn't have the power to do so, which was the Miller case, and she had to then rush through an Act of Parliament in order for her to issue the notice. This is just about issuing the notice to leave the European Union, so we haven't even left yet. We don't even know what we're doing. And finally, so she lost the court decision, which was not very sensible to actually make to prejudge a court decision. Courts don't tend to like it, even if you're, whether you're dealing with just a rear end shunt or a major decision, major constitutional decision. Don't take the court for granted is the lesson there. And finally, in March 2017, she issued her Article 50 notice, which gave us 2 years to quit. Essentially setting up a situation where we would have no deal unless some sort of transition arrangement could be agreed. So the clock is ticking. Now, the UK had always had this sort of slightly ambivalent, this is a thing from the turn of the last century, looking at infidelity, popery and socialism or something. There's Britannia sitting there proudly with lots of morally high-sounding quotes from the Bible right next to her. And we'd always had this sort of aloofness, so it's no surprise that the UK voted to leave. And also, if you look at the opinion polls right back over the last 10 years, the EU has never been terribly popular as far as the British are concerned, partly because we don't really know very much about it. We only speak English, and we don't really do our constitutional education, so we don't really know what it does. And that made it very difficult for the British public to choose fact from fiction. So I'll just go through the institutions. Some of you may know these things, some of you won't. The European Parliament, we were told as part of the Vote Leave campaign that the European Parliament Europe was completely undemocratic. That is absolutely not true. The UK, we elect via proportional representation representatives who go to the European Parliament, and in the past the European Parliament was simply a talking shop. It was a great thing to be, because you had, not obvious responsibilities, although they were quite important. You could haul European officials into account, you could get reports done, there was a conciliation process. But now, and certainly since the Treaty of Lisbon, the role of the European Parliament is more significant because they are part of what's called the trilogue of legislation. And as it weirdly happens, I'm dealing with some of that stuff today. The trilogue is where the Parliament negotiates legislation with the other two major law-making institutions, the European Commission and the Council of Ministers. So it is our elected representatives are part of the lawmaking process in Brussels. And here's the other thing. Well, I say Brussels, it's partly in Brussels and partly in Strasbourg. That itself is bonkers. So everyone lives in there with temporary accommodation because they keep shuttling all their stuff and shuttling off between Strasbourg and Brussels for reasons I don't even know. I don't even want to know, to be honest. But that's the way it is. But they are elected representatives, and in a funny sort of way, they are more accountable than our own MPs, where we don't have PR, we don't have proportional representation, and we tend to, there's a lot of MPs which don't change hands very often, shall we say. And inside Europe there are European political parties. One of the European, and what happens is domestic parties align themselves as one of these larger groupings, if you like, in the European Parliament. And whether or not you are part of those groupings depends really how much currency you've got in the European Parliament. Now, and with the European institutions. Now, there is the Conservative Party, the governing party in the UK at the moment, was part of the European People's Party, which is, as you can see, the largest of the European parties. And then, for some reason, when David Cameron became Prime Minister, he decided to leave them, which is a kind of centre-right coalition, and join the European Conservatives and Reformist group, of which the UK Conservatives were one of the largest members. It was daft, because as you could see, that put them straight into a minority party, and they were really there with, at one point that included the AfD, kind of far-right German party that everybody was complaining about. It was an incredibly difficult decision, and actually as part of the British negotiations to leave the European Union, it put the Conservatives in quite a small place, because they are essentially with a whole load of people who are walking along the corridors next to the wall talking to plants. My apologies to any politicians who that refers to, but you know what I mean. It was a yes. Anyway, I've got to be slightly careful of libelling. Anyway, the European Commission is the main lawmaking body of the European Union. It is, to some extent, unelected, although each Directorate General is headed by a European Commissioner who are appointed by Member States. We have one, and I've completely forgotten his name. You've got Juncker, who's the President, and that's our chap. Let's check him out. We have something in the environment. We used to have banking. Lord Hill was our commissioner until Brexit, and then he had to resign. And so we've been. You can see immediately we started to lose influence. The moment we did the Brexit vote, we started to lose influence in the Commission. So we have. There's 20 commissioners. Oh yeah, we do security now, and I forget what he is. He's a career civil servant. I'll check it out. Oh, I'll have to look. Hold on. Bear with me. Should have done that. Junkers is the president of the commission. Sir Julian King. Anyway, that drafts the legislation, which is then approved by the Council of Ministers in consultation with the European Parliament. The European Commission also polices member states. What it tends to do is the legislation drafted by the EU, if it isn't to do with some of the major competences, which I'll come on to in a second, that is set strategic goals. So there might be environmental goals, there might be air quality, so the environmental stuff, it might be there might be goals in terms of DG Connect. It might be something to do with the way our systems talk to one another. They set these strategic objectives and then they leave it up to the member states very often to implement them. So in a sense you can see why member states feel emasculated, because some of the quite cool stuff is done at a European level and they're no longer responsible for it. And then what the Commission does is it also polices member states. I have literally just come off doing a complaint to the Commission about the UK, Germany, the Netherlands and Belgium for failure to comply with some European legislation. And so they can then police member states and take them to the European Court of Justice. Again, you can see why people don't like that. The European Court of Justice then has the ability to levy significant fines against member states. We'd be talking about, I think what I'm looking at is about £70,000 a day, maybe more. But then as part of that trilogue process you have the Council of Ministers. Now the Council of Ministers is one minister for every member state, and that will be the relevant minister. So for fisheries it'll be the fisheries minister or the Secretary of State for the Environment, depending on who wants to go, and they'll sit around a table and they'll decide as part of that process too. So there is another accountability there. Oh, and you also have to remember that the Commission itself is made up often of placed people from the member states, so there's permanent representatives, so the member states do get a good say as to what's going on. But traditionally there's always this sense of competence creep. The sheer ability of the Commission staff and the ECJ tended to mean that if there was doubt over who had competence, the member state or the Commission, the member state would lose out. That has, the last cases, the last 4 or 5 years haven't followed that trend though. So again we have a situation where legend has it in one way, but actually practice has now changed. The presidency of the Council of Ministers, the people who host these ministers, changes every 6 months. Ironically, we were due to have it in March 2017, not 2019, hilariously. But it's now with Austria, and I can't remember who's going to have it instead. And then the other final institution, there are a lot more institutions within the EU, but these are the ones that are really important, are the European Court of Justice. And what that does is that is a decision-making body for all European law. So if there's a European law element to it, I'll go back to my original slide back here, you're going to find out something that the UK courts can refer on a point of, say, competition law, which is a sort of central European point, to the European Court of Justice. And the European Court of Justice will decide. Where are we? And then it'll refer it back to those. There we go. Bang. And then whatever the outcome of the case will be decided by the domestic court. Or the ECJ can do proceedings can be initiated by the ECJ through the ECJ by member states, by the Commission. I think the Parliament can do it, but it's exceptionally difficult for individuals or interest groups to access the European Court of Justice. They don't have what's called standing, or as lawyers would say, locus standi. Judges are appointed by member states' governments, the senior judges, and they sit for 6-year terms. So of course there'll be plenty of British judges who would have sat in the European Court of Justice over the years. So we're not friendless in any of these institutions, it's just that we don't really know about them. Ironically, in all of those four institutions, business is pretty much always conducted in English. It just means that to work for the Commission, to be Commission staffer, for instance, you have to have 3 languages, which is fine if you're Dutch, which, no offence to Dutch people, very few people speak, so you have to speak a couple of other languages. But for the English, we are terrible at foreign languages, so we haven't probably made up the opportunities there that we could have done. There are various ways of bringing it. I mentioned cases can be brought by individuals. Rarely, generally, you can get a preliminary hearing in a case. Van Din for the Home Office was one where an individual who had a poor criminal track record was wanted to test whether or not they could come to the UK, and they could. Yes, that's probably enough for that. Commission v UK, just that case, was one where gender legislation was not brought properly by the UK, so the Commission sued them, or took them to court and forced the UK to change its legislation. Now, source of legislation, the primary source is the European treaties. Unlike the British Constitution, which doesn't really have a constitution, it seems to have a lot of traditions, conventions, and a few mulled acts and things like the Magna Carta, but basically we have an unwritten constitution. All the powers of the European Union are written down. They largely were codified under the Treaty of Lisbon. You can look it up, you get the consolidated treaties, or the Treaty of Functioning, and the Treaty of Functioning, the European Union, it tells you what the European Union does, what it's got competences for, and how it does it. It's all written down, very simple. Yes, they are. They've been consolidated into one document, and you can find that document by just following that easy link on slides. This makes up the EU bodies, but more importantly it sets up what are called competences. They realise that sovereignty is a toxic word, so instead they call it competence, which sounds very kind of staid and easy. And they have 3 different types: exclusive competence, shared competence, or shared power, I should say, shared competence, and what's called complementary competence. For our purposes, the ones we're really concerned with are exclusive and shared competence. Exclusive competence is over the customs union and the rules of the internal market, and the customs union is basically the trade relationships between us and the rest of the world, and the internal market is all about free trade within the area. So that is, once you're in there, the EU then does your jobs, which mean the EU is the only people who have trade negotiators operating on the international scene. We haven't had any for years. So, and actually, as I know in my own job, these are specialisms which are difficult to come across. The longer you do it, the better you are at it, as a rule. And setting up those trade negotiations, as anyone who had anything to do with the Versailles Treaty after the First World War, it can make or break a country. So we need to be a little bit careful about this. Although there are people there, Nick Clegg, the former leader of the Liberal Democrats, his wife, for instance, Miriam Gonzalez, is a trade negotiator for the EU, and probably much cleverer than he is. Rules of the internal market, monetary policy. If we're in the euro, interest rates in the euro are set by the EU. And the one weird thing I get involved with is the management of marine biological resources under the common fisheries policy. So for some bizarre and unknown reason I cannot possibly begin even to guess at, the European Union in its own infinite wisdom has decided that it wants to be in control of mesh sizes for fishing traps in the North Sea. I've got no idea why they want to do that. That's nuts. And the common commercial policy. The shared competence means that they make the rules, but we can go a little bit further than that as long as those rules are in concert with whatever the EU makes. So, internal market, some aspects of social policy, economic, social and territorial cohesion, agriculture and fisheries, except for the conservation of marine biological resources, so that's things like subsidies, environment, consumer protection, transport, trans-European networks, energy, freedom, security of justice, some elements of public health, though that's very limited, research, development, space, development cooperation, humanitarian aid, again those are limited in reality. So the ones that's interesting: consumer protection, trans-European networks, the environment, agricultural policy. They're quite, they're kind of a large chunk of what government does. And again, I can see why member states why the UK might want that back. Getting it back, however, is a slightly different thing. But don't forget, we can always do that as long as we've still got power in those areas. We just need to make sure we hit the minimum benchmarks. For instance, we can always have more stringent environmental measures in the UK as long as we meet the minimum requirements of being a citizen of the European Union. And as a lot of this stuff is based on the major economies, us, France and Germany anyway, I mean, environmental protection legislation to some extent is based on our own stuff. It was drafted, after all, well, the lead draftsman on that was Boris Johnson's dad, Stan. So, behind this there are 4 guiding principles of free movement of goods, which is interesting. The free movement of services, which has never really happened, not quite to the same degree. I'm a lawyer, I can't practice in France, I can't even practice in Scotland. Free movement of capital, that's interesting. We used to have capital restrictions. There were limits on how much money you could take out of the country. And freedom of establishment. I can work in any part of the EU. And actually that's interesting because all this immigration kerfuffle that's going on, there were significant things the UK government could have done, because establishment is only about putting businesses in places. It doesn't mean you can't necessarily automatically just go to another country and claim dole. So the UK government had more discretion to stop European migration, but for some reason I just think it was too incompetent to be able to actually work through the process. And actually that is a good reason, because if the process is so complicated you can't really understand it, then that is a legitimate reason to step out of it. But even so, I think if they'd applied more brain power, I think they could have put a brake on European migration before it got too much. And anyway, of course, migration from outside of the EU has nothing to do with the European Union. It remains Britain's sovereign control. There are various methods of control. It has the legislation developed by the Commission, and normally EU regulations which pass straight into law, and directives which normally set a timetable up for the member state to enact its own laws. And once the deadlines are up in European directives, then they are enforceable against public bodies anyway. So Marshall and Southampton Area Health Authority was retirement legislation, and it had passed and it was applicable to Southampton Area Health Authority because it was a public body. And even British Gas, similar case with British Gas, that was deemed to be a public body even though it was a private company, because it was providing a utility, large public service. So once these things are passed, they can be quite toothy, which again is the problem, is that the EU did pass a lot of very detailed legislation. Right, now to go back to the start here, so how does Brexit work in all this? And I've put a asterisk next to Brexit as I did at the start, because I'm not actually, even now, I'm not quite sure what people mean by Brexit. Leaving the European Union is almost impossible. It's impossible to do it in such a way that you don't have a relationship. It is more like a divorce. You're going to have to have some aspect of agreement with the other party. Even, I was thinking about it, even if we default to WTO rules, we're still going to have some sort of trade relationship with Europe. So the idea that we can sort of easily part company is, I'm afraid, complete and total nonsense. I think someone said, Liam Fox, I think, said it was the quickest trade agreement in history. Nonsense. I mean, history has already proven him wrong. But that aside, if we take it as leaving the European Union, well, let's just explore this process a little bit more. So how do we trade with the rest of the world? We'll have to leave the customs union if we want to do our own trade arrangements. And now there's a whole thing about the single market and the customs union and how that works, which is it goes miles over the top of even my head. But my question really is what do we do with all those competences now we have them back? And this probably goes on to something that we haven't necessarily thought of, because the UK has been a member of the European Union for 40 odd years, and in that time it itself has changed significantly. So we've devolved an awful lot of power down to the constituent parts of the United Kingdom, except for England, which is still run by the UK, which never ceases to surprise, it's bonkers really. So once you take out the European legislation, in order to keep that binding glue together for the UK, you're going to need to set some strategic objectives at the UK level. So this is particularly important to things like environmental legislation, where you could see widely differing regimes happening, in England, Wales, Scotland and Northern Ireland. Or fisheries, which I'm up to my neck in, where you're already seeing, because the UK weirdly devolves control to fisheries out to the 200 nautical mile limit, which I've not been able to find any country in the world, bar Belgium, and they do it for their own particular reasons, which does that. So you end up with very fiddly little bits of legislation going on in different constituent parts of the UK, and the UK not really being able to cope with that, because the whole system has developed under the auspices of EU law. So the only thing to do there would be to undevolve some of those powers. Now, I don't think the Scots in particular are going to like that. So watch that space. Personally, I think the devolution is probably it's probably as big a problem as the third one, which is what will our relationship with the EU be like? And that seems to be that's very much as up to the EU as it is to us. But because we've issued this Article 50 notice giving us essentially a no deal, which I think is completely unpredictable what happens there, but I can't imagine it's good. Our back is far more against the wall than the EU's as far as that's concerned. So they're going to be calling the shots. So we'll see what happens. And then to all of that, you've got Mrs May's rather odd decision to call a general election just after she'd issued the Article 50 notice, which was nuts because she ate into even more of this 2-year period, and lost her majority. So she's got to then take the deal back that she's done to the EU to Parliament, which Parliament might not like it, and so you end up in a totally unpredictable situation. I've got no idea what's going to happen. But it's going to be very interesting. Suddenly we're all going to become constitutional lawyers. And Henry VIII's powers. So once you've gone through this process, you've got to give... I said at the start that ministers generally have powers which are very limited, like setting the Severn Bridge toll and not making the Severn Bridge an independent city-state. But the sheer volume of stuff, you've got 40 years worth of law which is going to be dumped on not a particularly well-functioning Parliament, it must be said. Parliament, it's just not as good as it was. The job of an MP is almost impossible, so you're not necessarily getting... Some MPs are excellent, but they're not, just between you and me, some of them aren't the brightest in the barrel. So what you're going to do is drop a whole load of law onto essentially ministers to rewrite in a very short space of time, and those are called Henry VIII's powers, and it gives enormous power to whoever happens to be in the room at the time, but I suspect they won't know what to do with it, to be honest. So there's plenty of room for significant bungling. Anyway, that's it. Watch this space. It's interesting because I think this whole Brexit process has put into sharp reflection what we do in the UK, and I think rather sadly that we haven't really understood A, how the UK constitution works, and B, how the European constitution works, and C, what the thing is going to look like after we've done all of this. Well, speak to you soon.